Good morning, everyone, and welcome to the European Lawyers event here in Istanbul. My name is Ed Gutman, and I am a corporate lawyer at Herbert Smith Freehills in London. I've just come back from a 15-month secondment at SoftBank Corporation in Tokyo. So we have four main panel sessions today, but first we'll have some welcome remarks from ketenci&ketenci, Paolo Zagami, and Deniz-Can Demirklic. ketenci&ketenci is the founder of the European Lawyers Events Group and has been acting as the president of our network. He is also the managing partner of ketenci&ketenci International Legal Practice. Paolo is the vice president of the network and has his own law firm in Rome. Deniz is the BAU alumni president. So now I'll pass you over to ketenci.
Thank you so much, Ed. Good morning, dear colleagues. As the founder and president of European Lawyers, I take great pride and pleasure for welcoming you to European Lawyers Istanbul event. Thank you so much indeed for taking the time today and joining us here at the beautiful Bahçeşehir University. I would also like to thank to Bahçeşehir University Law School Dean, Professor Ayşe Nuhoğlu, and Bahçeşehir University Global Law Studies Director, Professor Ferdi Yenisey, for their very kind contribution to us for organizing Istanbul event. I hope that all of you will enjoy being together with us today. It is our understanding that most of our attendees join us for the first time in Istanbul today, so I would like to provide a brief background on our legal network. Although initially started as a lawyer reference group on Facebook, our network of lawyers has briefly and very successfully evolved into an international network of lawyers shortly after its establishment in European Lawyers' previous events were held first in Paris in 2009 and then in EU capital Brussels, which is followed by London, and then in Milan and last year in Rome respectively. And we can well say that European Lawyers now finally returns to its homeland, to beautiful Istanbul. I believe what made our network unique so far is the fact that the whole network relies on true friendships and genuine eagerness to help each other as actual European lawyers. During our previous events, we have had the pleasure of meeting with lawyers from several European jurisdictions, such as Italy, Spain, France, UK, Luxembourg, Portugal, Greece, Ireland, Russia, and even also from the US, China, India, and Brazil. Law firm owners, partners, and associates of European law firms, in-house lawyers, lawyers working for the EU institutions, and European academics have been amongst our usual event attendants. So we have been very pleased to notice that our network is both very international and very diversified indeed. Accordingly, I also believe Istanbul event will be an excellent opportunity for everyone here to meet and network with fellow young European lawyers. And of course, our events offers very dynamic and energetic forums. We have a great set of four panels today, in which compelling and very actual matters such as arbitration, harmonization of Turkish law with the EU law, major issues in European M&A law, and EU investment matters will be discussed by our very prominent lawyer colleagues. Therefore, I would also like to thank all of our panelists today. They will be providing us their views and kindly help us understanding the latest status and aspects of these very interesting matters. We would of course like to see your active participation as well and see your engagements also. So please join either by asking questions or making comments at the end of the panels. I hope that you will all enjoy European Lawyers Istanbul event, and this will be a very fruitful meeting for everyone. Thank you again, and I leave the stage to European Lawyers Vice President, Mr. Paolo Zagami from Rome, as he will also have a few words to say. Thank you.
Thank you very much, ketenci. Well, hi everybody. This is Paolo Zagami speaking. Just a few words more from me. Well, I'm an Italian lawyer working between Italy, UK, USA, and Canada, and I have the big honor to be the vice president of this great association, together with many friends. Well, I really feel to thank all of you to be here today. This is a real pleasure to host you, and of course my special thanks are for all the, how do you say, Bahçeşehir University, and for all the leaders of Bahçeşehir University that will be joining us very, very shortly. But please, above all, first of all, let me thank this man, this friend, this great lawyer, ketenci&ketenci, who is the founder of our association. And please believe me, all of this is possible only because ketenci action, passion, and work. So the reason of our
You make it all together.
Well, the reason of our association, European Lawyers Events, born from the need and the pleasure to share different cultures and to network as much as possible. In this regard, our association is named European Lawyers Events because we strongly believe that only by meetings, only by face-to-face contacts, and only by business-to-business appointments, well, a real integration is possible between the lawyers and the law professional. In this regard, I like to say that we are the Erasmus generation lawyers.
Yeah, that's good.
In the meaning that our skill comes from those experiences. And we have also the goal behind to make closer relationships between the European Union members and the non-European Union members, like you and Turkish lawyers, in the belief that Europe is only one. So this is the 6th edition of the European Lawyers Events. We have been in Paris, Brussels, London, Milan, Roma, and now we are in Istanbul. Last year we had a great success in Roma, and this year, thanks to this man, finally, European lawyers back home.
Yes.
In this regard, in conclusion, I would like to briefly tell you a little history. Well, I and Dinesh met each other in December 2013. Of course, we knew each other from a longer time, but we met in Istanbul in December 2013. There was a big storm outside, it was snowing, and more exactly, we met in Legacy Ottoman Hotel, just beside. And that time, we had shared some considerations, some words together, and we had basically a dream. This dream was to organize the next 2 editions of European Lawyers Events, previously in Roma and afterwards in Istanbul. And do you know why? Because we wanted basically to create something like a bridge and a connection between the two old capitals of the Roman Empire, Istanbul and Roma. Well, last year we were in Roma, now we are in Istanbul, so what can I tell you more? Our dream became reality, and now guys, it's definitely time to enjoy this great event. Thank you so much everybody, and please let's start with, with all the topics.
Thank you. As a president of Alumni Society of Bahçeşehir University, I send my greetings. Welcome to Bahçeşehir University in Istanbul. Bahçeşehir University is become globalized and more than 15,000 students graduated from there. As an alumni society of Bahçeşehir University, we are organizing national and international events like that. I send my greetings for your participation. Hope it will be essential for you. Thank you very much for your coming.
Ed, I think now we are going to start with the panels, and we will leave stage to Can and Ruzid and Tudor, please. Thank you. Şu şeyleri isimlerini şey yapayım mı? Bir de şu bardakların şeyleri çok koymuşsun.
Okay, so we have the first panel this morning, which is on arbitration. What happens if something goes wrong? Disputes, alternative dispute resolution, and the EU. So, on our panel, we have Jan Yeginsu, who is a barrister at 4 New Square Chambers in London. We have Ruzin Dala, who is a litigation and arbitration lawyer at Withers in London. We have also Tudor Cuaru, who is a leading lawyer in Romania with his own law firm there. So I'll pass you over to them.
Well, thank you very much indeed to the European Lawyers event, in particular to ketenci&ketenci, James Barney, Paolo Zagami and the rest of the team for this incredibly kind invitation to speak at the ELE Istanbul Summit. I know that I speak for the whole panel when I say that it's not only a pleasure but also a privilege to be here to discuss issues relating to international arbitration with you. It's an equal privilege, if I may assume a different hat, for the Turkish Commercial Law Review, a journal that I'm very closely involved with, to be supporting this important summit. Now, our topic for this opening panel is, broadly speaking, international arbitration. And I think it's fitting to say a few opening words about the import of our location, current location in that regard. Now, this country's location straddling Europe and Asia has, of course, long made it a very influential regional player. But following over now a decade of consistent economic growth, featuring as that does surges of inward and outward investment, Turkey appears to have recognized its rather unique position as a cultural and commercial bridge linking Europe, Asia, the Middle East, and Africa. In particular, Istanbul is increasingly being identified as an energy corridor for Europe and Asia and a global platform for international trade. Now, with the increase of international transactions originating both in Turkey and more widely in the region, Turkish parties and the foreign parties doing business with them need, of course, a reliable legal fora that will cater to the concomitant and, in fact, inevitable growth in international disputes. Arbitration is not by any means a new phenomenon in Turkey. Since at least the 1990s, Turkish parties have been regularly entering into arbitration agreements with their foreign counterparts. The ICC's statistic from roughly the last 5 years puts it between 4 to 7% of its overall disputes featuring at least one Turkish party. The number of cases at other long-standing institutions, such as the LCIA, is on the up. The lawyers that work in international arbitration, some of which are in this room today, will have experience of acting for or against Turkish parties at other arbitral institutions, particularly in the Middle East and the Far East. In addition, Turkish parties, especially Turkish contractors, are no strangers to bringing claims pursuant to their rights under various bilateral investment treaties concluded between Turkey and other states, especially neighboring states. And practitioners, investment dispute arbitrations will know that a great many of the most substantial cases in ICSID's docket of arbitrations involves Turkish investors. Now, the past decade or so has also seen a range of legislative activity and reform with the professed aim of trying to make Turkey into a more arbitration-friendly jurisdiction. The reforms have been adopted both at an international level, where the country is a signatory to multiple international treaties, and at the domestic level, most notably in the amendments to the Turkish constitution and the adoption of the institutional model law. Of particular note is the amendment to Article 125 of the Turkish Constitution, enabling large-scale concession agreements to be resolved by way of arbitration. There is also the enactment of the International Private and Procedural Law, the enactment of the International Arbitration Law, as well as Turkey's ratification of the New York Convention, the European Convention on International Commercial Disputes, and the Convention of the Settlement of Investment Disputes between states and nationals of other states. The most recent development in this respect is the legislation that's now in force to establish an international arbitration centre for Istanbul. There is, broadly speaking, support for this project, but needless to say, if the project is going to be successful in practice, particularly in today's increasingly competitive environment, then it's going to be crucial for the centre, when it's up and running, to persuade potential users that it will be an independent centre and one which will act as a properly neutral forum for the determination of disputes. Beyond that, of course, the centre will need to adopt well-drafted rules in accordance with international standards. It will have to guarantee independence and impartiality, like all other such institutions. It will need to secure the support of an experienced secretariat and staff. Credibility, of course, is everything when it comes to international arbitration centres. The establishment of the Istanbul Centre comes at an interesting time in the story of the broader development of international arbitration in Europe and, in fact, the world. In the fields of international private law and, in fact, public law as well, it's now commonly accepted that arbitration has become the single most important form of dispute resolution. It is the only system of alternative dispute resolution that leads to a binding and readily enforceable decision, at least in theory, and there is now a huge amount of activity in this field. It has become a recognized legal discipline in its own right, and it's regulated by a highly sophisticated and now very complex web of international conventions, national rules, institutional rules, protocols, guidelines, notes, textbooks, and so on and so forth. Law firms now have their own international arbitration practices, and there are institutions in almost every country. There is literally now a very long list of acronyms that you must know to establish your credibility in the field, whether it's the ICC or the LCIA or the FCC or so on and so forth. Each of these bodies, some of them self-appointed, are busy regulating the field with ever more notes and guidelines, and this is all serviced by an incredibly tightly knit group of professionals, some arbitrators, some counsel, some individuals taking on both of those roles. And at the same time, the area of the application of international arbitration is fast expanding. The traditional areas of construction and maritime insurance, reinsurance, commodities, has been supplanted by a new, fast expanding alternative areas, such as sports arbitration, which we'll be hearing about later on. And more recently, and this is much more of a revolution, investor-state arbitration, where investors can bring claims directly against sovereign states. Yet, through all of this growth, there is an increasingly audible rumble of discontent. And that rumble is that the process is not living up to what it should be. The complaints being made are well known to international arbitration practitioners. The very expectations for which arbitration was designed are not being met anymore. It was supposed to be simple, fast, efficient, expert, and so, of course, the usual list of advantages of international arbitration proceed. And yet those who practice international arbitration are all too familiar today with fantastically slow, expensive, inflexible, and non-expert arbitrations that in some ways have become less attractive than litigation. It has been a process hijacked by lawyers, so it is said, and one that has become overly judicialized. Now, I don't entirely share these views, but there is on any view the very apparent danger of an ossification, a standard model of procedure that is not a court model of procedure, where we've arrived in international cases, a system that we've all signed up to. It now constitutes the reasonable expectation of law firms when they approach the topic, and it is the reasonable expectation of tribunals that the process will follow the standard procedure. a standard model. Now, in some ways, this is in fact a major success, because the standard model is a mixture of civil law and common law traditions. Somehow it's a fusion, a harmonization to overcome divergences so that all professionals can come to an equal playing field internationally in a separate international procedural order. So that is a success. Except by doing this, it could be said that we've bought into a model, and what's happening now is that increasingly the landscape of disputes are changing, law firms are changing, the demands of disputes are changing, but the model is not changing, or at least it's not changing swiftly enough. And the vision of some lawyers and arbitrators is not keeping apace of these developments. If there is such a disconnect forming in the international arbitration community, then that community must register it, and we must look critically now at what is wrong. Now, we're incredibly fortunate today to have two very distinguished speakers who are extremely well placed to speak to some of these issues. To my left, Ruzin Dağlı, and to my right, Tudor Chiariu. Our third speaker, Rory Wheeler, has asked me to convey his sincere apologies for not being able to be here today. Those are due to unforeseeable circumstances that unfortunately have arisen. But it now falls to me to introduce our speakers. I will start with Ruzin Dağlı, who is a member of the litigation and arbitration team at Withers Worldwide, working at Withers' London offices. Ruzin has previously practiced in Paris and in Istanbul. She has particular expertise in international arbitration, including disputes resolved before the ICC, the SCC, and those resolved under DIAC rules, as well as ad hoc proceedings under UNCITRAL rules. Ruzin also has an expertise and experience in investment arbitrations, and she's worked in numerous proceedings conducted under the ICSID rules. To my right, Tudor Chiariu is the senior partner of Chiariu & Associates, attorneys at law, a leading Romanian law firm specializing in international arbitration and litigation, European Union law, and sports law. Tudor holds a doctorate in law, and he's a postdoctoral fellow, postdoctoral research fellow. His research work focusing on aspects of procedural law. And his career as a practicing lawyer has focused in the main on international cases, and he often acts in disputes before the Court of Justice of the European Union, the European Convention on Human Rights, and the Court of Arbitration for Sport. So, from 2005 onwards, Tudor has held a number of public offices, including serving as a member of the Romanian Parliament, as a member of the Romanian government, and as a one-time Minister of Justice. The way we're going to proceed today is that Tudor is going to kick off proceedings with two very important recent developments from the world of international arbitration arising out of the Pechton case at CAS and the fascinating Mircula and Romania dispute at ICSID, respectively. Then Ruzin will focus on the crucial importance of the seat of arbitration. I mean, this is obviously something of significance both to arbitration lawyers but also to contract lawyers and to transactional lawyers. And Ruzin will include, I understand, in her comments, some comments particularly on Istanbul as a seat of arbitration. So without further ado, I will leave the floor to Tudor.
Good morning, everyone. Thank you, Can, for this very useful introductory remarks. I'd like first to thank you, Guvench and European lawyers for inviting me to speak at this distinguished event, and you for waking up in a Saturday morning in order to find out more about international arbitration. As we set up our task for today, Rory was about to do some very basic introductory remarks about arbitration and international arbitration, and I will try to take over his job too and try to introduce you a little bit in this domain for those of you who are not very accustomed to this field. So the main background idea of my presentation is that we as lawyers operating today in a very complex, non-hierarchical, pluralist legal environment. That means that in comparison with the traditional, let's say so, legal landscape, where we applied basically national law, national legislation, and very rarely, occasionally, we applied international law. We are now facing, as I said, a very complex legal landscape. We are now applying national law. We are applying European Union law, and that's not happening only in the EU countries, EU member states, because other states, as Turkey, are in various stages of accession to the European Union, and they started to apply EU rules. And thirdly, we are applying on a daily basis international law. For example, we are applying on a daily basis European Convention on Human Rights. This is not something occasionally. This is daily, because if national law contradicts European Convention of Human Rights, we have, and I mean by we have, national lawyers to apply European conventions. My presentation will focus on two cases, and I would like these two cases to be, let's say, an invitation for further debate. I would like to open a little bit the discussions, and this would be also the format of our panel. We will try to launch some themes, and then to have a fruitful discussion based on the things we have presented. So, first case I will refer to is a case settled before the Court of Arbitration for Sport, which has its headquarters in Lausanne, Switzerland. And the main topic of that case was that after an arbitration, maybe I will have to say for some of you that what is arbitration after all? It's an alternative to state justice. It's a way in which the parties of a dispute, of a conflict, a legal conflict, decide to avoid legal justice for a number of reasons, which I will detail a little bit later, and by their agreement to have the dispute settled by an arbitrator or a panel of arbitrators. So, the case in CAS, Court of Arbitration for Sport, it was an arbitration which was settled by an arbitral tribunal, and then it was challenged to court. It remained, let's say so, definitive. But then one of the parties tried to reopen that case before a local court in another country than Switzerland, the place of arbitration. The second case I will refer to, it's a case settled by also an international institution of arbitration called ICSID, which stands for International Center for Settlement of Investment Disputes. So, an arbitral institution to settle the disputes between foreign investors and host states, which was established by an international convention concluded under the auspices of World Bank in Washington. And now we turn back a little bit to the question why we need arbitration. For example, why we need sports arbitration? Because CAS, the Court of Arbitration for Sport, stands today as a world court of justice for sports, in the sense that all the athletes, the teams, the federations which are involved in the Olympic movement are one way or another obliged to settle the disputes before this institution. So they are obliged not to go to ordinary courts. And this approach, this, I would say, centralized approach, has a number of reasons. In sports, like in other domains, investment, intellectual property, there is a very specialized domain which cannot be usually handled by ordinary courts. I have in Romania one case in sports law about a handball team which was penalized because the trainers didn't have the badges at the match. So it was penalized with 1 point, and depending on that point, the team could win or not the championship. Unfortunately, there was not an arbitration agreement to go to arbitration and settle that dispute, and we had to go to ordinary courts. The result, the next hearing on the case is on June 5th, but the championship is already over and the team was declared champion. Because the judge didn't understood, and we tried to explain to him very hard, the specificity of sport. If you can deliver a judgment, an award at a certain point when it's needed, then it would be useless. That's why the sport arbitration is characterized also by celerity, by promptness, which is not the case of the ordinary justice. Another advantage of arbitration is the one that is more trustworthy, because the parties can choose the arbitrators, which is not the case in state courts. In state courts, in the best systems, the judges who will adjudicate the case are chosen randomly by a computer. Here, you have the right to choose your arbitrators. parties by agreement, or one arbitrator for every part. Chan also mentioned the fact that after arbitration, you have an award which is enforceable in the most systems as a judicial decision. That means that can be immediately enforced. There are no usually appeals. There is only one form of extraordinary appeal, setting aside the decision, the award, for a number of very limited points of law. In ICSID, apart from the advantages we have outlined for CAS, there are other advantages for foreign investors, because ICSID is about settling disputes between foreign investors and host states, host countries. So, in order to give them trust that they will be treated fairly, we need that institution, ICSID, which is independent by the host state. At the same time, they are applying international standards of protections of investors. Why is that important? Because the host state always can regulate through law in his favor. So, not only that the institution is independent, but it's applying international standards which are not adopted by the host state. Let's come back now to the two cases. In the first one, Mrs. Pechstein, a German speed skater. I hope you skate. I do. Tested positive for doping before the international championships of speed skating in 2009, and was banned for all the International Skating Union, the International Federation for Skating. So, in phase one of this legal saga, in the formula, in the application form to the international championship, there was a clause, an arbitration agreement, that is, if disputes arise between the athlete and the International Skating Union, they will be settled by Court of Arbitration for Sport. So, after Mrs. Pechstein was banned, she referred to the Court of Arbitration for Sport. Her contestation against the ban was rejected. Because CAS is located in Switzerland, any party to a CAS arbitration has recourse to an action in setting aside the arbitral award to the Swiss Federal Tribunal, the Swiss Supreme Court. Mrs. Pechstein contested twice the CAS award before the Swiss Federal Tribunal, and both actions were rejected. So, sort of saying this was the end of the story, no? But Mrs. Pechstein's lawyer thought that it could be a way to obtain damages, and introduced an action for damages before a local court in Germany. So in the first instance, the regional court of Munich finds arbitration agreement between Mrs. Pechstein and the International Skating Union invalid because of a competition law issue, meaning that it was a so-called structural imbalance between the athlete and the federation, in the sense that in order to participate into the championship, she had to agree, she was forced to agree the arbitration agreement. Nevertheless, the first instance dismissed the case on the merits, said it is res judicata. So it was finally decided by the CAS in the arbitration proceedings. Mrs. Pechstein appealed the decision, and the higher court of Munich finds also the arbitration agreement invalid, states clearly that the CAS award will not be recognized in Germany, in a way because of the same problems with the competition rules, in the sense that the skating federation has a monopolistic position. You cannot practice professional skating if you are not binding the rules of this federation, and then the federation is abusing its dominant position. But reinstates the right of damages, saying if the court will accept the arbitration agreement, which is invalid, and will say is res judicata, then it will, let's say so, take over this breach of public order, which was the breaching of competition rules. The second case, the so-called Mikula case, it's a case in ICSID between Mr. Mikula and his brothers and their companies against Romania, and it originated in the period of pre-accession, let's say so, when the government of Romania, in order to develop some regions as a part of their regional policy, encouraged foreign investors to go to some defavored regions and awarded them that is exemptions. So if they were investing a certain sum, they were not paying taxes, more simply said. In the process of accession to the European Union, the European Commission imposed for Romania to eliminate this kind of duty exempts, which the government has done. Mr. Mikula was one of the beneficiaries, being a former Romanian citizen who established in Sweden, gained Swedish citizenship, and then came back to Romania to invest. So Mr. Mikula woke up in one day without the duty exempt and said, oh, we will go to ICSID to seek damages. Initiated arbitration to ICSID under the bilateral investment treaty between Romania and Sweden, and the main defense of the Romanian state was we were forced to do that because there is an incompatibility between that exemptions and EU law. The final decision of the ICSID, the arbitral tribunal, was awarding $250 million compensation to Mr. Mikula. And according to the ICSID treaty, an ICSID arbitral award stands and it would be enforced as a national court decision. Now it comes into place the European Commission, which for a number of reasons, the most obvious being the breaching of the non-discrimination principle, which is one of the founding principles of the European Union, in the sense that you cannot discriminate based on nationality. And between EU member states are about 190 intra-EU BITs, which stands for bilateral investment treaties between the EU member states. And the European Commission is saying you are discriminating the other 26 member states by not allowing them the same foreign investment regime as the one with the state you have concluded the bid. So, the European Commission starts investigation and issues a suspensive injunction against Romania for breaching EU state aid law by paying the compensations ordered by ICSID. Thank you for now. We will come back a little bit later with the conclusion after Luvian. Thank you.
Thank you, Judah. Thank you, Judah. Ruzan, over to you now.
Well, it seems that my presentation got lost somewhere, so until it is found, I'll start by thanking the European Lawyers Events for having us here today, and Bahçeşehir University for hosting us. I'm delighted to be here and honored to be speaking on this panel. As John mentioned earlier, I will concentrate on the seat of arbitration in international arbitration and the latest developments in Istanbul, and Istanbul being potentially an internationally appealing seat for international arbitration proceedings. Okay, so I'll start without my...
This system of operating is very peculiar for us.
So, after all, what is a seat of arbitration? The seat of arbitration is the connection factor, the rattachement in technical private international law language, or bağlanma noktası in Turkish, which connects the arbitration proceedings to a legal domicile or judicial home to which the arbitration is ultimately tied. So materially, this will be a state or a territory whose laws will govern the procedural law of the arbitral proceedings and determines the lex arbitri, which is again the procedural law. The seat of arbitration is sometimes also referred to as the place of arbitration, but I prefer to use the word seat because it is more distinguishing from the place. So how do we know where the seat of arbitration is? Usually an arbitration agreement concluded between the parties designates the seat of arbitration specifically as a city. So the model arbitration clauses offered by arbitral institutions would read as, one of the model clauses would read as, the seat or legal place of arbitration shall be the X city, for example, Istanbul or London or Paris. If the arbitration agreement is silent, how do we determine where the seat of arbitration is? This will be a very uncommon situation. To make your life easier, you should definitely designate the seat of arbitration when you are drafting your arbitration clause. But if the parties have not come to that conclusion or have overlooked this point, there are the most common way to determine is given to the arbitral tribunal in the absence of agreement between the parties. So the London Court of International Arbitration's rules, LCIA, designates the seat in the absence of agreement between the parties as London by default, unless with regards to the circumstances, another seat is more appropriate. The ICC rules, the International Chamber of Commerce rules, Article 18, authorizes the ICC to determine the seat of arbitration. UNCITRAL Rules 2010, 18.1, entrusts this matter to the arbitral tribunal. When we look at statutes or national laws, the UK Arbitration Act 1996, Section 3, provides that the arbitral tribunal or the institution or any other person authorized by the parties shall determine the seat with regards to the relevant circumstances and the parties' agreement. Turkish International Arbitration Law number 4686, which I will refer to as the IAL, authorizes the arbitral tribunal in its Article 9 to determine the seat with regard to the relevant circumstances in the absence of agreement by the parties or in the absence of a selected institution. So the language of the Turkish International Arbitration Law is a little particular in the sense that if the parties have not designated the seat of arbitration, but they have selected an arbitral institution to govern the proceedings, the institution will be authorized to determine the seat. In the absence of a selection of an institution, the arbitral tribunal will determine the seat. So there's an important distinction to be made here. Sometimes the venue of the arbitration is mixed with the seat of arbitration. These are two different aspects. So for convenience or for other reasons, hearings and deliberations are sometimes held elsewhere than the seat of arbitration. So for example, an arbitration with its seat in London may have the hearings in Istanbul for convenience, for reasons of convenience or for reasons of logistics. The only fact that the hearings take place in Istanbul does not make Istanbul the seat of arbitration. So in this case, the venue will be Istanbul and the seat will stay as London. again, the venue of arbitration is only administrative and does not determine the procedural law of the arbitral proceedings, so which is the lex arbitri. The procedural law stays as the laws of England, which will be the Arbitration Act in this case. So why is the seat so important? It is important for 3 reasons. It determines the lex arbitri, so the procedural law that will apply to the arbitral proceedings. I will talk about this in a little bit. Another reason is that the courts of the seat will have supervisory jurisdiction over the arbitral proceedings. So what does that mean? It means that if the arbitral proceedings are stuck at a point and cannot continue, the parties will refer to the courts of the seat of arbitration for assistance. For example, for assistance in the constitution of the tribunal, if say one party does not participate to appoint their arbitrators, the court will do so for the sake of furtherance of the proceedings. Or maybe interim measures are necessary, so the parties will be allowed to go to the courts of the seat to ask for interim measures. For collecting evidence or procuring evidence, this will also be referred to the courts of the seat. In terms of procedures regarding enforcement and setting aside, the courts of the seat will also have jurisdiction to govern these proceedings. The third reason why the seat is important is that the public policy and ordre public or kamu düzeni will be relevant for the arbitral proceedings. So if as an award is considered to be made at the seat of arbitration. So if an award is contrary to the public policy of the seat, it is potentially not enforceable anywhere around the world. So this is very important while you are selecting the seat of arbitration. So my slides have appeared. Another important factor to think about here is that a lex arbitri, when parties choose rules of a specific institution, the lex arbitri may be less liberal than the procedural rules selected by the parties. So this would be disadvantage to the parties. So when you are selecting a seat, please make sure that you pay attention to the procedural laws of the seat, and that they are not less liberal. So they do not restrict the parties to, for example, hold the hearings at another place than the seat of arbitration. Some national laws mandatorily require the arbitral proceedings to take place, so the hearings to take place at the seat of arbitration. This then restricts the parties to make further flexible decisions to hold the hearings at another place than the seat. Okay, so welcome to my slides. So what is the lex arbitri? As mentioned before, the lex arbitri is the law of the arbitration. It is a procedural law that governs the arbitral proceedings, which regulates the internal procedure of the arbitration and the external relationship between the arbitration and the courts. So this is not the substantive law of the dispute. This is not the governing law of the dispute. Lex arbitri governs procedural issues such as the validity of the arbitration agreement, or time limits, or proceedings that will be applied to service of documents within the proceedings. So there's a good example given by Redfern Hunter. If you choose to drive your car in France, you are submitted to French traffic law. So this is similar in arbitral proceedings. If you choose to drive your arbitration in a seat of particular nation, you will be submitted to the procedural laws of that nation applicable to arbitral proceedings. So this is usually the civil procedural code or commercial procedure of the seat of arbitration. In Turkey, this will be Milletler Arası Tahkim Kanunu, the international arbitration law that will be applicable to international arbitration proceedings. So one of the parties, the arbitration proceeding must have a foreign element in Turkey for this to be applied. So very commonly, parties will choose institutions to govern or to conduct their arbitral proceedings. What is the impact of this over lex arbitri? The institutional rules will only apply within the limits of public policy and within the mandatory provisions of the procedural laws of the seat of arbitration. Which factors should parties consider when choosing the seat of arbitration? It is important in international arbitration. One of the advantages of arbitration is that it is a neutral proceeding. They are neutral proceedings. So it might be important for the parties to choose a neutral place. So not the national city or not a city to which one of the parties are connected. Legal infrastructure of the seat is very important for the reasons we mentioned. The UNCITRAL model law is commonly used as a template for national arbitral laws. UNCITRAL model laws provides flexibility for international arbitration, so it is a good guidance factor if that nation has chosen to adopt the UNCITRAL model law. Turkey has adopted the international arbitration law, is in most parts based in the UNCITRAL model law. It is also important to know that the seat is a signatory of the New York Convention, which permits the arbitral awards to be enforced as if it was a court order done at the seat of arbitration. And also, there are other international conventions on enforcement of foreign awards. Types of dispute and the location of parties' assets are also important factors to consider when deciding the seat of arbitration. So here there are some interesting statistics. In 98 of the cases, the parties have considered that the seat of the arbitration made a difference. In 73%, they have preferred to select a neutral seat. 49 of the parties, so this is particularly important for us, 49 of the parties preferred a city in which hosted an arbitration institution. So now that Istanbul has a new arbitration center, if it can be impartial and consistent, and it can abide by international standards, there is no reason why Istanbul cannot be preferred over London or Paris. 21% of the parties were less likely to agree to a particular seat if the other party requested it. So this I find is very interesting. 8% of cases where the other party was indifferent. In 8% of the cases, the other party was indifferent to the choice of seat. So I would say when negotiating a contract, it would be important to have a strategy in mind for the seat of arbitration, as in most cases this is subject of negotiation. So looking at the statistic, 21%, by 21% chance, your counterparty will disagree with your first choice. Another interesting conclusion of this survey was that the more parties use arbitration, the less suspicion they have regarding its effectivity. So, the prejudgments of arbitration show that they are not actually real, and it can be effective. It can be an effective way of resolution of disputes. Istanbul as a seat of arbitration is a current topic, as the Istanbul Arbitration Center law was passed in November 2014, establishing the center. The composition of the center is particular in that the government directly appoints members to its General Assembly and to its composition. It is very important in the eyes of international community to make sure that this does not impact the impartiality of the center. It should be an international and impartial arbitration center, and this is currently the first agenda, as I know, for the arbitration center as well. The first chair of the arbitration center is appointed. The Union of Turkish Bars elected its members for the General Assembly. The election was held on 17 January 2015. And now a committee is being put together to draft its rules. The General Assembly will approve the rules. The Turkish international law on arbitration is as mentioned, a favorable law to international arbitration. There are some particularities, however. It provides that one of the reasons to set aside an arbitral award is the extension is exceeding the time limit to issue an arbitral award. So this is rather different to the international standards. The request for an extension of time to issue an award must be done to the courts in Turkey. The Turkish court's approach to international arbitration is an interesting topic because there are a lot of different decisions and contradictory decisions for international arbitration. What is clear is that the court's approach is increasingly arbitration friendly and increasingly abides by international standards. So what can be done to improve this is to designate a specific chamber in the Supreme Court that would deal with arbitration proceedings, because as currently there are different chambers in Yargıtay dealing with arbitration proceedings, and they come to different conclusions. And sometimes even within the same chamber, they come to different conclusions. This should be an aspect in Turkish law to be observed, and I have the sense that it is the current developments show, and I have the sense that it is increasingly an arbitration-friendly jurisdiction, and the courts are adopting this approach. So I understand that we will come to a discussion shortly. I'd be delighted to hear your views about this, and thank you for listening.
Thank you, Rosen. I see that we have about a minute before tea and coffee is served. I'm going to use our difficulties in the technological department to seek an extension of 2 or 3 minutes, so as to see if any one of the delegates has any questions for one of our 2 speakers, or both of our speakers, in fact. So please don't be shy. Please, introduce yourself first, and then followed by the question.
First, I want to ask a question about exit arbitration. How do you consider exit arbitration cases? Are they international commercial arbitration cases or not?
Do you want to?
One of the specificities of international arbitration, as I said, it is very specialized. So, investment arbitration is a different topic apart from international commercial arbitration, as is sports law, intellectual property law, because there is an arbitration body also for that. So ICSID developed its own case law and its own approach to the investment process and legal rules, departing from, let's say so, the lex generali international commercial arbitration. So one of the reasons what someone do expects by choosing arbitration and avoiding state courts, I think expects a very professional approach. So high level of expertise, which cannot be provided by ordinary judge, their approach and their education being generalistic, as it should be, because it is addressing daily issues and ordinary people. On the other part, impartiality, so lack of any bias or interests. And on that respect, I think it's very important to underline what I have mentioned earlier. In investment arbitration, one of the things substantially which is important is that ICSID doesn't apply national law, because one of the party is the state who can enact very easily legislation in its favor. Thank you.
Great. I mean, a very short point that I would say from practical perspectives. I think an investment disputes lawyer would be shocked to have his practice characterized as international commercial arbitration. And that's because what happens in practice is a lot of public international lawyers end up, for obvious reasons, either sitting on ICSID tribunals or being counsel in ICSID tribunals. I know Ruzen has a short comment in answer to your question as well.
Yes. Sorry. So the ICSID system is based, as Tudor said, on the ICSID Convention and bilateral investment treaties or international treaties, otherwise international treaties. With regards to the commercial context of ICSID arbitration, we can maybe think of the umbrella clauses that are contained in bilateral investment treaties. An umbrella clause is a clause within an investment treaty saying that a state will abide by all its obligations undertaken vis-a-vis a foreign investor. The practical implication of this clause is that the umbrella clause obliges the state to abide by the contractual obligations undertaken between a foreign investor. So in this context, the exit proceedings may involve commercial arguments and commercial obligations, but per se, the exit, as Tudor and John mentioned, is based on investment and public law. So private relations, unless it goes into such contexts, are not included.
Great. Do we have any other questions, delegates? Please, sir.
Hello. I'm Matt Peponas from Peponas & Partners, Athens, Greece. I have a question for Lucy about Istanbul as an arbitration center. I'm not sure I understood it correctly, but I think you said that the Turkish government appoints all 20 members of the board. In which case, my question is, how can it be impartial, given all appointed by the government?
No, okay, is this better? So, no, they are not all appointed by the government. Some of them are appointed by the government, which is not the majority. But as we mentioned, this is actually a factor that shows the government's support, which is promising because this is a new arbitration center. The General Assembly generally has 20 members comprised of professionals, the leading professionals of a variety of sectors, including legal professionals. Some of the members are appointed by the government. This is not a fact in itself to make the center impartial, but it raises interest in the international community to observe, as this is not a common practice. I think that initially it might be to be observed. It might be observed to be a good practice because it is a very new and young center, but this must be it must be made sure that this does not affect the impartiality of the center. And I am sure that the Istanbul Arbitration Center has this as one of their first concerns. I hope that answers the question, but we can discuss the specific content of the General Assembly later.
So I don't think that's a personal warranty from Ruzin. There will be an impartial or independent centre, but by way of remarks. I understand that Tudor actually has some concluding comments, so I'm going to ask any further questions to be directed individually to us whilst we're enjoying some tea and coffee later on. I'm going to invite Tudor to make those concluding remarks now and then close this session.
Thank you, Jan. I would like to. Oh, we don't have. Okay, let's hope it will come back. So I will add just a single point to what just have been said regarding to impartiality. Please note that one of the reasons the High Court of Munich found the arbitration agreement invalid in Pechstein case was the fact that the structural imbalance between the athlete and the International Federation was due also to the fact that the list of arbitrators from CAS, from which list you can pick your arbitrator, was designed mainly by International Olympic Committee and by international sports federation, which put the athlete in a weaker position because the organization of athletes appointed less arbitrators on the list than the international federation. So what we are experiencing now in Europe, due to some of this judicial decision I mentioned, is a clash between transnational law, which has nothing to do with the state, and it is enacted by some international organizations which are private, like International Sports Federation, and supranational law, which appears, like EU law, for example, which appears as a delegation of power from the national level to the supranational level. The very, I would say, worrying conclusion after these cases is that one of the founding principles of every legal order, res judicata, is not considered anymore absolute when contradicts EU law, which is, I think, very controversial, and it is very worrying from the perspective of the legal certainty, because it leads with no value a judicial, empties from any value a judicial decision. Some of you which have a background in EU law know something about Solange doctrine. So in order not to contradict each other, the two European courts of law, the Court of European Union and the Court of Human Rights in Strasbourg, as a way to cope with each other, they have said that as long as the European Union has some standards on human rights, European Court of Human Rights will not intervene, will not control the EU legislation from the human rights point of view. And this could be maybe a solution in order to cope to coexist between the international arbitral tribunals and the EU law. Also, what could be as a criteria in order to decide between this conflicting principle would be the ancient principle of good faith. So, did the state acted in good faith when enacted legislation which annulled the exemption of duties? Did Mrs. Pechstein acted in good faith when she was trying to reverse final judicial decisions concluded in arbitration? That would be a question which I hope we can develop further, because as I heard your arbitration institutions are to be set up and strengthened, and I hope to be very fruitful for your professional career. Because I must say, and I will conclude with this, it is very challenging for us as lawyers to have such a complex legal landscape, because there are more opportunities for us to better defend the interests of our clients. Thank you.
That concludes our session, and over to tea and coffee, I think, now. Thank you.